Okay, it is live. Very good. We want to welcome the attorneys for the pretrial hearing we have scheduled in docket number SCR 21-0001, the special court of review in the inquiry concerning the Honorable Sarah Eckhart. And per prior order of this panel, consisting of Justices Charles Krieger, Justice Stacy Trotter, and myself, Brian Quinn. We welcome you via Zoom. Appreciate your participation. We noticed that you had filed two motions. I just saw a copy of them this morning. Well, two items. One was a stipulation of facts, and the other was a motion to have the hearing occur on a stipulated record. Were those the only two filings you've made so far?
Yes, Your Honor. I made those filings on behalf of both parties this morning. The evidence, aside from the stipulations, the exhibits are also mentioned in the stipulations. They're designated therein. I think our idea was that we would file the exhibits for the court after this hearing within the next day or two here.
And you've already talked, just to be correctly understand, you've talked about the particular exhibits, correct?
Yes, we've got an idea of all the exhibits that are going to be submitted. They are the exhibits that are designated in the stipulations. And unless Mr. Kauser has anything to add to that, we're ready to go on all those stipulations.
Just curiosity. I'm sorry, Mr. Kauser.
I was going to say I agree with what Mr. Graham said. The other thing Mr. Graham and I discussed was holding off on filing the 10-page summary brief that the court called for, pending a ruling on our motion to submit to put the case before the court on commission. Our thought was, if we do the 20-page briefs pursuant to the submission, that there would be no need for the 10-page briefs today.
Okay, so in your stipulation, you've asked for opportunity to brief as well, file a 20-page brief?
That's in the request for submission, Your Honor. What we've done in there is added a request for briefing. That typically in these courts of review, what happens is we have a trial and then post-submission briefing that follows essentially the schedule that we laid out in the request. And so the only thing we would be skipping here is the in-person trial.
Okay. How long, assuming arguendo, we were to grant your motion to submit on stipulated record and briefing, do you have a proposed date for that briefing to be filed, or do you just want us to set it, which we would be happy to do?
In the motion, out of deference to the court, we used the date for the trial as the initial trial brief, which would be the examiner's trial brief, followed by the respondent's response a week later, and any reply brief from the examiners a week after that. I think we can make that, but I'm not opposed to stretching it out a little if people would want to stretch it out a little. But I think given Thanksgiving, that the earliest that I would be able to submit my brief would probably be the 6th.
And that schedule is acceptable to the respondent, Your Honor.
Again, the judges have not talked about it. I will say that this thing has been pending for a while, and the sooner we can dispose of it would be better. I understand that the holidays are upon us. Just my initial, when you were talking about scheduling, was not extending it, but maybe contracting it. But we will talk among ourselves to decide that, and we'll go from there. I had a list of things to talk about, such as witnesses, exhibits, times, accommodations, things like that. But that tends to, your motion to submit by stipulated record tends to make those moot unless we decide not to grant it.
I have a question, counsel.
Yes,
Submitting the case based on stipulated facts to either of you, or would either of you anticipate the need to develop additional facts that may be pertinent to the issues we have to address?
Not for examiner's part, Justice Trotter. I think we've got everything that we need in the stipulations and the exhibit, the stipulated facts and the stipulated evidence, the documentary evidence. In fact, I think we may have more than we need, but from the examiner's point of view, I think we're good with what we have there.
And I generally concur with that, Judge, except to say that these stipulations are more extensive than anything that's been before the court before. We've developed the factual stipulations based on what evidence we believe would be presented by live witnesses if we were to have the hearing on December 6th. So Mr. Graham and I both worked on that pretty extensively, and I think the stipulations cover it. So I don't think we need to submit any additional facts.
And I ask because I'm sure both of you are aware, as we are, that during battle, there are matters that arise that are not anticipated that need to be developed, but both of you are comfortable in addressing and representing to us that that's not the situation.
From examiner's point of view, that's the case, Justice Trotter. I think that if anything, there might be some legal arguments that we might be surprised by, but those are things that we can deal with through argument, and I don't think any other evidence will be necessary.
And I concur, Judge.
curiously, if we were to grant the motion and submit stipulated records and any of the justices have a question with regard to a fact that they think pertinent, how would you propose to address that?
That's a good question, Chief Justice Quinn. I hadn't anticipated that. I mean, I think that it's possible we could handle that in writing as well if it comes up. But beyond addressing it in writing, I'm not sure what we would do with that.
That makes sense to me, Judge.
Would it be a situation where you would agree to submit that particular, if you had a contested fact issue, submit it by affidavit under agreement that the panel gets to judge, determine who to believe in that affidavit?
I think examiners would not have an issue with that. Of course, we rely on the panel to judge the credibility of the evidence generally anyway. So I think that would be fine from our perspective.
Judge, we think that would be a good solution.
Okay. Let's do this. Bobby, real fast, can you put the attorneys in a separate room for us, please? You're on mute, Bobby.
You want to stop the live stream?